Attend the court. The Honorable Supreme Court of the State of New Mexico.
Good morning. You may be seated. Thank you. Good morning. We are calling S-1-SC-39641 Salas versus Guadalupe Credit Union. Mr. Looney, you may enter your appearance. You have 25 minutes.
Yes, Your Honor, Stephen Linney on behalf of the petitioner, Guadalupe Credit Union.
You may proceed. 25 minutes, 5 on rebuttal.
Your Honors, on behalf of the credit union, I would like to thank you for your time and attention today. What this appeal raises as the core issue is whether a rule of this court, Rule 2107, which is a rule of civil procedure for the magistrate court, whether that rule is this court's interpretation of a statute, that statute being 36-2-27. The Court of Appeals accepted the proposition urged by the respondents that Rule 2107 apparently accepted that interpretation, that Rule 2107 is in fact this court's interpretation of Section 36-227. And if that's not the case, then I think it's clear that the plaintiffs had no standing and that the complaint failed to state a cause of action, and the district court was correct in dismissing the case.
Mr. Looney, who has control over, how the procedure in front of the courts, the legislature or the New Mexico Supreme Court?
This court, Judge Ryan, there's no question about that. We don't.
So I really struggle with the argument that 2107 doesn't control the day, coupled with decades of case law. I mean, I'm really wondering why this has made it to us, why we are here, because it feels like a pretty specious argument to say that the statute controls, despite the fact that we have created a very narrow path through our rulemaking.
And I understand that. I mean, the Rule 2107 does, as well within this court authority, to promulgate rules governing the practice of law and procedure in the courts. That's not what the appeal is about, Your Honor. What I would like to say further upon that point, though, is what the Court of Appeals has done essentially is determine that the alleged violation of a rule of civil procedure serves as a basis for standing and a cause of action under the under the Unfair Practices Act. And I believe that's unprecedented. To my knowledge, this court has never held that a violation of a rule of its civil procedure, a rule of civil procedure in any court, is the basis for standing under any legislation of the state, including under UPA or under Section 36-227. That's unprecedented. If it's the view of this court that violation of a rule of civil procedure gives rise to a UPA claim and provides standing, I think we've opened up a real box of Pandora's and a floodgate of litigation. Anytime somebody is perceived to have violated a rule of civil procedure, now they've got a UPA claim.
I think the argument may be a little broader than that, that it's the wrongful prosecution of a debt collection by its rule civil procedure violation, but in essence, it's a UPA claim because it was a wrongful prosecution of a debt collection case.
Well, yes, Your Honor, and that's the allegation, and the Court of Appeals seemed to accept that, but I would respectfully suggest to the court, it is not wrongful. It was not wrongful for the credit union to have represented itself pro se in magistrate court by virtue of this legislation.
That legislation it's as though it doesn't exist anymore. We have usurped that legislation through our rulemaking because under doctrine of separation of powers, that is our obligation to do it, Mr. Looney. So we have clearly declared that that statute does not control. The only mechanism by which an LLC corporation, whatever, can represent itself in magistrate court is if it's a closely held corporation, and this is not a closely held corporation.
I understand. Yes, but I still respectfully suggest that that being true, it does not follow that a violation of a rule of civil procedure constitutes a violation of the Unfair Practices Act.
Going straight to Justice Thompson's perspective, which this is much broader than that. The UPA is a remedial statute that is designed to capture a great deal of things. And the thing that that the plaintiffs are attempting to capture here is the fact that there was misrepresentation in the process of collecting a debt. That it's and that does qualify under the statute and the rubric of what the UPA is designed to protect. It just so happens that the rule provides some basis for it, but it's not standing alone the reason that the UPA is triggered for purposes of filing a complaint, for purposes of standing.
Well, Your Honor, I think that's respectfully a very broad interpretation of the UPA that I don't believe
our case law says it is to be interpreted broadly. It is a remedial statute to protect consumers. You can drive a semi-truck through the UPA.
But is it not the prerogative of this court to regulate the practice of law? and to make rules and regulations governing the practice of law. It seems to me that if the court were to give that broad of an interpretation to the UPA, it's now relinquished, in a sense, some of its authority to the legislature to determine that the unauthorized, that the appearing pro se in magistrate court, contrary to Rule 2107, is now a UPA violation. I don't know that this court has, any of its rules have ever been given that such a broad sweep to say that a violation, I am repeating myself and forgive me, but violation of rule of civil procedure is a violation of unfair practices.
It's not a per se thing at all. In fact, even you still have to prove, this gives you standing, arguably, but you still have to prove proximate cause damages and the other elements of the UPA. This is not a per se situation, as you're arguing.
Well, no, it is not. I agree, Your Honor. It is not a per se situation. We're arguing that in this appeal that there is no standing under the UPA, that the respondents lack standing under the UPA. We're not suggesting that they have proved the elements of the UPA violation. This case was dismissed under Rule 12b-6, so it's on the pleading. So accepting those pleadings, well-pleaded facts is true. The district court agreed that the plaintiffs, the respondents, lacked standing because the complaint failed to state a cause of action. And one of the reasons why the district court felt that way, and it's because this court's jurisprudence on the subject of unfair practice, unauthorized practice of the law, the way I read the cases, therefore, have always involved the representation of a third party, not somebody or including an entity representing itself pro se.
So you're saying, if I understand your argument, tell me if I'm wrong, that if somebody from Guadalupe Credit Union called a person who was in arrears on their note, said they were a police officer and they wanted to come see them about their debt, that there would be no standing there? Here, these people were representing themselves as lawyers to these third parties. What am I missing?
Well, the credit union never held itself out as being an attorney, never held itself out as representing these respondents.
No, but it held itself out as representing itself in these legal actions. That to me is representing yourself as an attorney.
I believe respectfully that it's representing yourself as a pro se litigant.
Practicing law.
For yourself.
Practicing law.
In Metro Court.
Right.
Yes.
So you do concede that the Guadalupe employees were practicing law?
Well, the district court found that, and I don't know that I can say that. I mean, I guess I'm not trying to be flippant here, but I mean, is appearing pro se practicing law? You're not a licensed attorney, I get that. So yes, I guess in some sense, I'm not gonna.
So where do you, sorry, we hold pro se litigants to the same standard as we do individuals represented by an attorney. It is de facto the practice of law.
I mean, I can see that. I'm not trying to be avoiding that. I mean, I think it is, but again, it's pro se, but it doesn't have all the other indicia of practicing law, such as representing the interest of third parties, drafting your own pleadings, giving legal advice, getting compensated for it. I realize you don't have to get compensated.
Your client, the representatives working for your client did just that. They filed motions in the magistrate court.
Using court of.
The forms don't matter. It's still filing a motion. It's not a scrivener's job. It's one thing if you have an employee filling out the form and then handing it to a lawyer to go file. But here, filing motions, negotiating settlements, pursuing judgments, those are all functions of a lawyer. It is, I know that you really want to hang your hat on this idea that they were just filling out forms. That is absolutely not a fair characteristic of what these employees were doing.
I'm not saying that's the only reason that they are not.
You just distinguished practicing law from not practicing law by the filing of motions. And these people filed motions in a court of law.
Yes, Your Honor, they filed pleadings that were approved by this court. They filled in the blanks on those. Okay, Your Honor, okay, judgment was used, okay.
Lawyers fill in blanks in forms and file them in. It's the filing of a motion.
What I'm suggesting to the court is that given the current jurisprudence of this court on the unauthorized practice of law, the facts of this case do not fit squarely into, for example, the Norvell case and the Guardian Abstract case, which in those cases, it was a representation of third parties, usually for a fee, giving legal advice to third parties. And okay, that may be a fine distinction. It is a fine distinction. It may not make a difference to this court, but I come back to what I think should give this court pause, is whether it follows from the violation of a rule of civil procedure that a party, here the respondents, have standing to bring a claim seeking damages under the Unfair Practices Act or Section 36-2-27.
Mr. Looney,
on that road.
how do you navigate 36-228.1B?
1B,
Provides that a person who suffers a loss of money or other property as a result of the unauthorized practice of law in violation of Section 36-227, which is now supplanted by the rule, may bring an action. So and it doesn't say harmed, a person who suffers a loss of money or other property while being represented by somebody who is engaging. It's more generic than that. And that's what the Court of Appeals relies on in part.
well, I would navigate that, Your Honor, by saying that that provision concerns a violation of 36-2-27, not a violation of the UPA. And it doesn't reflect or refer to a violation of the rule of this court. And I think I would say further, as we argued in the briefs, that even if there is a violation, even if the Guadalupe Credit Union violated Rule 2107, any remedy the response might have would be under Section 36-228.1B, not under the UPA. And respectfully, to say that a violation of a rule of civil procedure here.
No, we're talking about the statute. I'm talking about the statute.
Right.
And statutes other than the UPA are regularly used to trigger the UPA. It happens in employment cases all of the time. If there's a perceived pattern and practice of discrimination in violation of, the Human Rights Act or, some federal statute, that is used as a predicate in addition to the underlying claim to get to the UPA. So if I'm reading the Court of Appeals opinion right, they're saying the rule provides some information. The statute is a predicate violation to trigger the UPA, just like it is in almost any. You could have a lemon law case violates the lemon law statute, and then they learn that there's a pattern and practice of fraud or deceit, and they use the lemon law then to jump into the UPA. So that's, I think, what the Court of Appeals is trying to do in its opinion.
Well, the way I read the Court of Appeals opinion is that it determined that the respondents have standing because it accepted the concept and the notion that a violation of Rule 2107 may constitute a violation of Rule 36-227, and that it may constitute a violation of the UPA. I don't recall that the Court of Appeals specifically got into the detail that Your Honor just did about the application of 26-228.1.
I think that's what they're saying in paragraphs 11 and 12 of the opinion.
And again, I would submit that if this court believes that the credit union violated Rule 2107, and it does think so, it still, in my humble opinion, doesn't fit into our jurisprudence in this state, in that, to my knowledge, heretofore, there is no authority that a violation of rule of civil procedure gives rise to a cause of action under any statutory provision, whether that's the UPA or 36-2-27. I totally understand and agree with the concept that this court has rulemaking authority and plenary control and authority over the practice of law, including the unauthorized practice of law. But I think this is where we get into the rub in a conflict between potential conflict. I see it as a conflict in the legislature and this court when we're looking at saying that a violation of a rules of civil procedure gives rise to a cause of action. I mean, the legislature had a specific statute in mind to address the unauthorized practice of law. That is 36-227. That's the specific
Well,
should control over the general.
you're ignoring 36-228.1C. A person bringing an action pursuant to subsection A or B of this section shall, if the person prevail, I'm sorry, wrong language, wrong statute. D, the relief provided by this section is in addition to other remedies available at law or equity.
Yeah, yes, sir. Yes, Your Honor. That general.
So the
statute-
legislature wasn't limiting itself to a specific exclusive form of remedy. They said this is in addition to anything else, and nothing else is precluded. The way I read this statute.
Well, yes, sir. That similar language is in the UPA, and it's kind of a catch-all thing. And the legislature does, I think, from that intent to not just limit a remedy to that. I would not argue otherwise. But I think it gets back to this core question is whether, and if this court's view is that Rule 2107, apparently it is its interpretation, is this court's interpretation of Rule 36-227, then so be it. I think that would not be had been established for today. I don't know that it gives rise to a cause of action under the UPA, and I would argue that it doesn't. So, I mean,
Mr. Looney, if pretend the rule doesn't exist. The UPA uses language about that casts a broad net over loans and collection of debt. Is there an argument to be made by the plaintiff, and tell me why or why not, that you can set aside the rule of procedure, you can, and all of this, we're making a straight up allegation of a violation of the UPA. UPA provides that if there are deceptive measures taken in the collection of debt, that is within the UPA's zone of interest of protection. So you don't need the rule of procedure. You don't even need the statute if there's sufficient facts accepted as true for purposes of 12b-6, that they would have standing if they make a sufficient allegation in the complaint itself about misrepresentation or deception in a loan practice.
I understand your point, Your Honor. That's not what this case is. That's not how it was pled. And so based upon the allegations in the complaint and the theories raised in the complaint, I would respectfully submit that the district court was correct in dismissing it for failure to state a claim. Had they done as this court just suggested, we might not be having this conversation. It would be a different conversation, and the arguments would have been different. I still question, Your Honor, whether the legislature ever intended to insert itself into the province of this court by declaring in the UPA, either generally or specifically, by declaring that the unauthorized practice of law is a UPA violation. It seems to me our legislature understands its role in separation of powers. That's a function of this court to decide that. And I really doubt that, and I find nothing to support that the legislature intended to include any aspect of the practice of law as being a UPA, or to constitute a UPA violation. mean, but I might have some other points I might want to make, but I guess.
So I actually want to, and I'm sorry, I missed, you may have answered this in Justice Bacon's last question, but the complaint alleges that Guadalupe's representations, actions, inactions, omissions constitute unconscionable trade practice within the meaning of UPA. That Guadalupe willfully violated it. So it seems to me that while the rule might be relevant on the issue of an UPA violation, it's not dispositive. And I don't think there's anything that I can see really looking at this quickly that would show that. Because you seem to be arguing, well, they alleged 26, the rule and only the rule in their complaint, and I'm not reading it that way. Can you direct me to why you think that?
I'm sorry, Your Honor, forgive me. I didn't quite follow your question.
No, it wasn't good. I believe that Rule 2107 is not the sole thing they're hanging their hat on. I think the misrepresentation is under UPA, and I think the rule can be relevant evidence to that misrepresentation. Do you see what I'm saying?
I do.
Yeah, and I don't see anything in the complaint that solely alleges a violation of the rule. Instead, it's an UPA violation regarding the actions.
Well, Your Honor, I do read their complaint, I think specifically to say that they don't allege that the credit union violated Rule 36-227. They allege specifically that the credit union violated Rule 2107 and Rule 36-2-28.1. But 28.1 is a remedy. It's not a substantive right of action. So if I'm answering your question, I hope I am, did specifically hang their hat on 2107. And then they admit also that Rule 2107 provides no private right of action and no remedy. They admit that. So if we hang their hat on, they admit it doesn't apply, but they want to find standing under the UK in this circuitous route that this court's jurisprudence heretofore just hasn't supported.
If this were in district court, let's say it was a dispute over a larger amount of money. And it was,
Or what, Your Honor?
let's put this in district court. So it's a dispute over a larger amount of money. The collector brings in lawyer that's been disbarred. We've had an injunction that says you may not practice in the state of New Mexico. That is an authorized practice of law. That lawyer continues to pursue the debt collection. Is it your argument that they would lack standing to bring a claim because their only remedy is the unauthorized practice of law statute?
Essentially, yes, Your Honor. If we were in district court, it would be a different conversation. There you do need to be represented by counsel, unless you're an individual representing yourself.
And that duty is created how? The Supreme Court has said you have to have a license in New Mexico to practice law. We created that as well. It's still unauthorized practice. Why aren't you just pointing us to the statute?
Well, if I'm following your question, Your Honor, if we were in district court, I would submit to Your Honor that any remedy anybody would have would be under 36-227. Not any remedy, but any cause of action. Any remedy would be under 36-228.1. That would be the remedy. That's what the legislature has determined by a specific act. And there would, Your Honor, be no remedy in district court under the UPA.
Any questions, Judge Knoll?
No, thank you.
So some more. Thank you, Catherine. Sir Trinan, please enter your appearance. You have 30 minutes.
Good morning, Chief Justice Thompson, Justices of the New Mexico Supreme Court, and Judge Knoll. I'm Rob Trinan, and I represent the plaintiff respondents, Kyle Salas and the others. I guess the first point I'd like to address would be this idea that this isn't a big deal. That what we're really talking about, as we've heard from Guadalupe Credit Union, is a rule of civil procedure. But if we look at what is happening here, the unauthorized practice of law, this is a constitutional deal. The Constitution of New Mexico gives the sole authority to deal with who practices in the courts to this court. And this court has rules. These rules include the ethical rules, the rules of professionalism, and there's enforcement mechanisms for those rules through the disciplinary board. And those rules impose on the folks that are going to come into court and use the power of being an attorney. They require certain things, including things like candor to the court, professionalism standards. And that's why this is a big deal. In Norvell, which was a very similar case in a lot of ways, it dealt with a predecessor version of 107, the Supreme Court rule we're talking about here. It dealt with the predecessor version of 36-227, the statute that says except magistrate courts. And it dealt with collection agencies using non-attorneys to prosecute collection actions in magistrate court. And in that case, the New Mexico Supreme Court said, and this is in paragraph 26, we will not permit the practice of law by unlicensed magistrate courts lawyers who are unfettered by the strictures which apply to the rest of the legal profession. That's what we're talking about here. We're not talking about some rule of civil procedure. We're talking about the constitutional authority of this court to make sure courts stay forums of justice.
Well, their argument is there is a form of justice, it's just a different statute. If there exists an avenue for your client, it's not the UPA.
Well, Your Honor,
So you do have a forum. It's just not the one you prefer for whatever reason.
understood, Your Honor. Thank you for bringing that point up. So the Unfair Practices Act and the unauthorized practice of law statutes here mirror each other remarkably, from how they talk about private rights of action to the damage provisions to the last sections that also mirror each other that say these are in supplement to any other existing laws or statutes. They're intended to be to not cut each other off at any point.
But if we've supplanted the predicate statute that the legislature passed about the unauthorized practice of law in magistrate court, or the allowance of it, how do we take our rule and back in to be one? If you were filing under the statute and then you're going to the remedy statute, straight line. But we've supplanted the statute fairly directly. So how do we then piggyback the remedy statute onto our rule as opposed to the original statute?
Understood, Justice Bacon. So that is dealt with directly in two cases already. This is not ground that needs to be plowed into. In Norvell and in the Rivera cases, which dealt with unauthorized practice of law, they said, they pointed out that we're talking about a constitutional prerogative of this court to control who practices law in the courts, including magistrate court. And if to the extent there's a statute out there that suggests otherwise, that statute has to be read in harmony with the court's rules. So it's an issue of harmonizing the statute by the New Mexico Supreme Court rule in order to avoid a constitutional separations of powers issue.
Can you
It's a,
clarify something for me as well along those lines? And I asked opposing counsel, is it the rule that creates the UPA violation, or is the rule relevant evidence of a violation, such as a misleading statement and whatever else you alleged?
thank
Can you
you.
clarify that distinction for me, if my question makes sense, hopefully?
Your question makes sense, Justice Zamora. And the rule provides the evidence. It's the second alternative that you mentioned. So the Unfair Practice Act, as the court has mentioned, is interpreted very broadly because it's a remedial statute in favor of consumers. And it specifically covers collection of debt. It's also specifically covers in the enumerated list in 5712(2)D, a misrepresentations that a transaction involves rights, remedies, or obligations that does not involve.
And did you plead facts in your complaint that go directly to that litany that are outside of or separate from Rule 107?
Your Honor, what we pled was this is the unauthorized practice of law and the misrepresentation that these folks were allowed to do these things, file pleadings, prosecute lawsuits, and enter into settlements was a misrepresentation under 5712(2)D15.
So you clearly tether the conduct giving rise to a violation of 107 to the misrepresentation language in the UPA.
That's correct, Your Honor. And it goes back to Justice Zamora's point that Rule 2107 is the standard out there, sort of the standard of care that we use to establish that this is a misrepresentation.
Was it per se?
No, Your Honor, I don't believe the court could say it was per se. For example, let's say that there was a party that served 51 requests for admissions rather than the rules would say 50. But that would not qualify as a UPA violation because that doesn't fit within the standard that we see on 5712(2)D15. It doesn't involve rights, remedies, or obligations in a real way.
I guess my question is this, is the fact that based upon the allegation that this is the unauthorized practice of law, does that per se put you in under the UPA?
It does because the UPA's provisions fit in that situation. I hope that answered your
And
question.
is that D 14 and 15?
5712(D15) is a misrepresentation on that a transaction involves rights, remedies, or obligations that it does not involve, as well as.
How does a non-lawyer practicing law, how does that per se result in stating that a transaction involves rights, remedies, or obligations that it does not involve?
Because the person is in there acting as a lawyer. Anyone who would be there would think he is a lawyer by the fact he's filing the cases, prosecuting, appearing in court, making any argument, entering into the settlements. And so it's important to realize that the misrepresentation of the UPA does not necessarily require a statement. We don't have to isolate some specific words. It can also be an action. And that's specifically spelled out in the statutory language.
Does this more, I'm sorry, go ahead.
No, go ahead.
Does this more properly fit under unconscionable trade practice, 5712(2)E?
Justice Vigil, I was trying to get there, and I'm glad you bumped me up to it. That's also correct. We also believe that it fits under 5712(2)E1, which is taking advantage of the lack of knowledge, ability, experience, or capacity of a person to a grossly unfair degree.
Isn't it more closer fit there?
Well, I think they're both close fits, but I'll go with you if you believe it's closer. The other things that I thought it might be useful for me to address, Your Honors, is why allow private enforcement of the unauthorized practice of law statute? I mean, the statute clearly provides that as a part of the remedies, but why do that? And that is, it serves the goal that the court has that these things are enforced. And we don't have what we see in this case, which is folks in there unfettered by the rules of professionalism and the duty of candor and everything else.
Why isn't the remedy sufficient? Why isn't it sufficient? Or maybe it's the remedy is to go to the disciplinary board and have the disciplinary board enter injunctive relief prohibiting the bank from engaging in this conduct. Plus, I believe it allows for some level of monetary recompense. Why isn't that the path?
The reason that doesn't seem to be enough, Justice Bacon, is that it just doesn't happen. And what will happen if there is a private right of action, the case law talks about this usually in the context of our Unfair Practices Act of a UDAP statute. If there's a private right of action, that's essentially deputizing the private bar to bring these violations so that we have robust enforcement and we have real teeth to these.
But likewise, as an attorney, the bar could file the complaint in front of the disciplinary board with great ease.
Right.
Raise the specter of the unauthorized practice of law and have the disciplinary board be the prosecutor of this as opposed to the civil justice system.
That is true, Your Honor. But our legislature has chosen to do more than that. They've chosen to deputize private attorneys to make sure these statutes, both the unauthorized practice of law statute and the Unfair Practice Act statute, are robustly enforced. And, you know, we see the indicators of that in these broad private rights of action and in the fee shifting that's also provided for to give incentive for the private bar to enforce these. The other thing I think I would be remiss in not bringing up to this court is that we've been talking here about standing, and so we've been talking here about damages, but also in both statutes, in both the unauthorized practice of law statute and in the remedy section of the Unfair Practices Act 57-1210, we have clear indication in the language that when the relief is injunctive relief, that no proof of economic harm is required. And I just don't want the court to miss that point. It appears to have been missed by the Court of Appeals. I don't have any further presentation unless the court has questions for me. Appreciate it.
I have nothing further to add either, unless the board has questions of me.
One question on Candy Dancer. I want to understand my apologies. Want to understand your position on Candy Dancer that that involved business competitors. But it's your argument that there was a holding in that opinion that would have limited the cause of action in this case. And can you explain for me your reasoning for that?
Yes, Your Honor. Our position on Gandy Dancer is that that case speaks very specifically to the zone of interest and standing. And there's language in Gandy Dancer which stands for the proposition that when there's a specific statute available for the litigant to get relief under, in that case, it was the Construction Industries Licensing Act. That when there's a specific statute, as there is here with respect to 36-227, well, we're arguing that there isn't. Yeah,
I see.
but when there's a specific statute, under Gandy Dancer, this court said that it would be an unwarranted expansion of the UPA to interpret the UPA so broadly that it steps out of its function and into the realm of, out of that general statute of the UPA and step out of that and when there's specific statutes available, I'm kind of muddling a little bit, but because my point is because there's a specific statute available, maybe you cannot expand the UPA beyond its parameters, so to speak, and invade that over there. That's the zone of interest. That zone of interest was being protected by the specific statute.
Your argument is you would have to stick with B1 and the UPA would not be available based on that language in Gandy Dancer.
Yes, Your Honor.
Okay.
Thank you. All right, thank you, counsel. Thank you for your presentation. This case is now submitted. Court's in recess.
Report.